Alright, hey, in this video we're going to talk about the Supreme Court in action, so let's get right to it. Alright, so what happens when the Supreme Court makes an unpopular or controversial ruling? Well, as we touched on in the previous video, there are sometimes these questions about the legitimacy of the court. And these questions stem from the fact, again, that the power of judicial review is not directly mentioned in the Constitution. Also stems from the fact that federal judges are not elected. It's the least democratic branch of government. So this brings up the question, well, what's the proper role for the judicial branch? And there are essentially two answers. Some advocate for judicial restraint, while others tend to favor judicial activism. So let's define each of these terms and we can discuss this debate and what it means for the Supreme Court. So let's start with judicial restraint. This is the belief that the Supreme Court should, whenever possible, defer to the democratically elected branches of government. In other words, they should try their very best not to overrule congressional laws, or state laws, or executive actions. The reason being that people voted for congressmen, people voted for the members of their state governments, people voted for the president. Therefore, those people are just carrying out the will of the people. And to maintain democracy as much as possible, these unelected judges shouldn't be overruling their decisions, unless they absolutely have to. Because remember, it is the job of the Supreme Court to be guardians of the Constitution. That's essentially what Hamilton said back in Federalist number 78. But with the idea of judicial restraint, it means they should exercise that power of judicial review minimally, as little as possible. Whenever possible, let the elected branches do what they feel is best. On the other hand, judicial activism takes the approach that judges can and should overrule the other branches and states when they do something unconstitutional. They tend to believe that it is their job, it is their role to defend the Constitution, actively interpreting it in such a way that will protect minority rights or that will lead to social change. So this is going to greatly empower the Supreme Court and the judicial branch, because it's going to allow judges to make policy much more frequently. They will more frequently make use of their judicial review powers. Now, the idea here isn't that some judges would claim, oh, I'm a judicial activist, but rather this is typically something that people talk about the judges. And so when justices make a ruling that a person disagrees with, they often will criticize it as being an example of judicial activism. So that term has a critical connotation to it. It's the idea that the Supreme Court is taking too much power for themselves. They're not allowing the democratically elected branches enough power. So typically, if you hear somebody say that term, it's usually indicating that they disagree with the Supreme Court or with a particular ruling. So what can the other branches and states do if there is a controversial ruling by the Supreme Court that they just don't agree with? Well, at times, they may be able to ignore the Supreme Court's ruling. And the reason for this is that the Supreme Court lacks police power. They are not able to enforce their own opinions. They rely on the other branches, specifically the executive branch, and they rely on state governments in other cases to enforce their decisions. So if enough people disagree with it, if they don't view it as a legitimate ruling, they could simply ignore the Supreme Court. A good example of this is the issue of school prayer. School prayer is something that's not supposed to happen in public schools if it's led by a school employee. But throughout the country, in the 50 years or so since that Supreme Court ruling was handed down, that type of prayer takes place all the time, especially in athletics, pregame prayers, and that sort of thing, which technically shouldn't really be happening. But again, the enforcement is lacking quite frequently, and so that decision gets ignored. Another thing that can be done is that Congress could pass new legislation that kind of limits the effect of that court's ruling. A good example of this is U.S. versus Lopez, which we talked about in Unit 1, so hopefully you remember it already. U.S. versus Lopez ruled that Congress had overstepped their power using the Commerce Clause when they made the Gun-Free School Zones Act. So, after they did that, Congress just passed an updated version of the law and said, okay, since we didn't mention interstate commerce before, and the Supreme Court ruled that that wasn't affecting interstate commerce, then they just added a line to the law and said that you can't bring a gun to school if that gun has been involved in any form of interstate commerce. They found the loophole, and now that law is back on the books. So it's a little bit more narrow than it used to be, but again, they achieved their purpose. They limited the effect of the court's ruling in U.S. versus Lopez. Another option that Congress has is that they can propose a constitutional amendment. So a great example of this could be with the federal income tax. In the late 1800s, Congress had passed a law establishing a federal income tax, but it was challenged and the Supreme Court ruled it unconstitutional. They said Congress does not have the power to levy an income tax on citizens. So, what did Congress do? They proposed a constitutional amendment, what became the 16th Amendment, which gives Congress the power to levy a federal income tax. So again, the Supreme Court said they can't do something, propose a constitutional amendment, and if it gets ratified, then yes, Congress can do that. Now, another thing that Congress can do is they can alter the appellate jurisdiction of the Supreme Court. So there's a little bit of defining that we need to do here. The word jurisdiction refers to the ability to hear a case. The word appellate means on appeal. So it turns out that the Supreme Court, they choose which cases that they want to hear. So they only hear about 70 or 80 cases per year, and they have the power to choose cases from their appellate jurisdiction. So they get appealed to it from lower federal courts or from state Supreme Courts, and then the Supreme Court says, yes, we do want to hear this case, or no, we don't want to hear this case. It takes 4 justices to agree to hear a case. That's called the Rule of 4. And when 4 justices say that they want to hear the case, they issue what's known as a writ of certiorari, which is a command for the lower courts to give the documents, all the information about that case, to the Supreme Court so that they can rule on this issue. All right, so with that as our background, so again, jurisdiction, the ability to hear a case. Congress can actually just change the court's jurisdiction. That means that they can take away the court's ability to rule on a particular issue. This happened probably most famously during the Civil War, where Congress took away the Supreme Court's ability to rule on certain issues regarding freedom of the press. Now, at this time, there was a lot of censorship happening in both the Civil War and the Reconstruction era, and so they took away the Supreme Court's ability to rule on freedom of press issues because they knew that they were doing things that were pretty much in violation of the First Amendment. The Supreme Court actually had to rule on whether or not that was constitutional, and they did come back and say, you know what, Congress is allowed to change our jurisdiction, therefore we can't hear this type of case. So that's another avenue that Congress can take if they want to limit the power of the court in response to some kind of decision that they disagree with. Alright guys, thanks for sticking with me. Until next time, this has been a LaMoney production. Alright, thanks again for watching. If this video helped, do me a favor and hit that like button. Make sure you subscribe if you haven't already. I'll see you guys next time.